Yes, ma'am.
Good afternoon, Your Honors, and may it please the Court. My name is Ashton Jones. I am with Donati Law, and we represent the plaintiff, Mr. Reginald Jenkins. In the present case, Mr. Jenkins is appealing.
Do you want to reserve some time for?
Oh, I apologize, Your Honor. Thank you. I would like to reserve 3 minutes for rebuttal.
Okay.
Thank you. In the present case, Mr. Jenkins is appealing from the trial court's convictions on 4 counts. 2 counts of attempted first-degree murder and 2 counts of employing a firearm during commission of a dangerous felony, first-degree murder. In his request to overturn in his appeal, Mr. Jenkins Mr. Jenkins is appealing the trial court's decision based on the fact that he did not possess the requisite culpability for intent to commit a first-degree murder based on the fact of mistaken identity, that he was not at the crime scene. Under federal precedent set forth in Jackson v. Virginia and Tennessee Appellate Procedure Rule 13E in Tennessee, when examining whether evidence presented at trial was sufficient to support conviction, the courts determined whether, after viewing the evidence in a light most favorable to the prosecution, any rational trier of fact could have found the elements of a crime beyond a reasonable doubt. A prosecutor must be able to establish every single element in a crime. The applicable statutes to this case are TCA, Tennessee Code Annotated 39-13-202A1, which defines first-degree murder as a premeditated and intentional killing of another. For the prosecution to succeed in a first-degree murder conviction, there must be both premeditation and the intentional killing.
Let me ask you this. Just stop you for a second. Let's separate this argument just for a second. Okay. I assume the thrust of your argument in this case is the identification. Is that correct?
Correct.
Okay. I assume you do not have any argument really that the crime itself, the event itself, the facts don't support an attempted first-degree murder.
Correct.
Okay, because you have a lying in wait ambush basically in a car getting shot up. So I think that we can move past that, and you're looking at strictly the identification issue. Is that correct?
Correct.
Okay.
Regarding the identification issue, there were multiple problems with the case. The first case is the vehicle that was identified at the scene. The victims did not see the perpetrator himself, notably on this night. There were conflicting reports from Jenkins' wife, the officers on the scene of the crime, and even based on Pastor Ricky Floyd's testimony, which cast doubt on the vehicle's identification.
Well, they didn't know what type of black SUV it was to begin with, correct?
Correct. There were reports that it could have been a Tahoe, and then the next day, many hours later, the be on the lookout order was sent for a GMC Terrain, a totally different vehicle.
Well, that's after they got the video that showed the Terrain pull up and park right next to the Pastor Floyd and Mr. Thomas's vehicle, and the man get out of the black SUV, take his coat off, put the coat in the back seat, say something to Mr. Thomas, and get back in his car, drive off without purchasing gas or going inside, going across the street and parking this black SUV, correct?
That is correct. However, that SUV, the video was blurry and it was unable to clarify whether that was a GMC Terrain or a Tahoe.
And that black SUV then pulled out behind Pastor Floyd and Keith Thomas when they finished getting their gas and left the gas station, correct?
Correct.
And on the video, you can see the license plate number of this black SUV, correct?
To my recollection, it was blurry.
Well, they identified it and were able to find out that it was registered to the defendant's girlfriend at the time, wife at the time of the trial. Is that correct?
On the video, I honestly did not see a license plate on the video.
I understand, but you weren't the investigating officer and you didn't run the tags and find out that they had sufficient information to find out that it was registered to the defendant's, we'll call her wife, right?
Okay.
And so they checked, and it was a Terrain instead of a Tahoe, registered to the defendant's wife. So the logical thing to do is take the car into their possession and interview the wife, right?
Correct. They did interview Miss Baker.
And she said, although she later said different things, that that was her black Terrain and that was the defendant.
She did, but important to note is that she was clearly under duress in the video. She's in a coercive environment and is being pressured to answer a question.
Apparently, your car had been used to shoot at somebody. That would put anybody under duress, I would think. But she did identify her husband.
She did identify her husband, but at trial under penalty of perjury, she said, "That was not my husband. I was stressed out, and I did not mean to identify that man as my husband."
Okay, and so the jury heard all that, right?
Correct.
And they didn't believe what she said at trial. They believed apparently what she said during the interview, correct?
Yes.
Okay, thank you.
However, regarding that vehicle, while there was a shell casing in that vehicle, no gun was found on the scene or in the car.
Well, the fact that there's a shell casing found, I think, near the windshield, maybe, and it matched the other shell casings that were found. Even though they didn't have a gun, they were able to match the casings. So the gun that was used to fire those shells also fired the one that was found on the Terrain. Isn't that right?
That is correct, that those shell casings were likely related. However, because there was no gun to corroborate,
We have again, you don't have to have the gun. You have to admit that's pretty bad evidence to have this car and have a shell casing that just happens to be near the windshield. They don't come like that from the showroom. I mean, that's kind of incriminating, I guess is the best way to put it. Well, you would see that, wouldn't you?
that neighborhood where the shell casings were found, as a neighbor testified who lived near that intersection at Joe's, he testified that shootings were common in that area.
Okay.
Well, Mr. Tate said he estimated 9 shots that night. The officer went out the next morning and found 10 shell casings at the intersection where Pastor Floyd had pulled over and the black SUV had pulled up beside him and opened fire. Is that correct?
Yes, that did happen, but
And then they found, as Judge Campbell has pointed out, a shell casing that a TBI expert said was fired from the same weapon as the 10 shell casings that were found at the intersection. And that shell casing was found on the window crowd, in other words, outside the windshield of the black SUV that was owned by the defendant's wife, correct?
that is correct. But considering that there were multiple shell casings in that scene, it could be possible that the wife was driving by and got shot at.
Okay.
But furthermore, there was an issue at the gas station where the man got out of the car and Keith Thomas said that he was talking to him. That man may have said, as Pastor Floyd corrected in his testimony, that man did not actually say anything to them, but they thought they heard something, but it seemed like he wasn't talking to them and addressing them.
Pastor Floyd said he was muttering,
Right.
and Mr. Thomas said he didn't say anything negative. Isn't that correct?
Correct. The man did not appear to be talking to them and just appeared to be muttering to himself as he was getting gas.
But he still took that vehicle, parked across the street from the gas station, then pulled out behind them, started tailgating until Pastor Floyd pulled over. Then whomever was in that vehicle pulled up beside him and fired at least 10 casings as they found in the street, plus maybe 11 if counting the one that was found on the windshield, right?
Your Honor, that is possible.
I think that's the proof in the case.
How However, even at trial, Pastor Floyd said that he did not know Reginald Jenkins and that he had never seen him before. He stated, "I don't know this man, I've never seen him before." What that means is that there was likely no motive and no reason for Reginald Jenkins to have any reason to shoot at Pastor Floyd.
They couldn't find Mr. Thomas, is that correct?
That is correct. His whereabouts were unknown. Without the proper identification and clear hardline evidence that this was Reginald Jenkins, it's impossible to prove that there was intent, the prerequisite mental state for attempted murder. And even regarding the essential killing element of first-degree murder, Jenkins argues that he did not use a gun. The forensic inspector called at trial stated that the guns did leave unique sets of imprints on the bullets, but there was no way to determine how long the cartridge casings had been sitting out between the firing of the gun and when they were collected. To go back to what we were talking about with the guns, with the bullets, there was no way to determine when they were shot. They could have been shot days or weeks apart.
Okay, and again, the jury heard all this, right?
Yes.
Okay. And, you know, the fact finder, the jury's the fact finder. So if they make a determination, you know, we really can't overturn it unless it's just absolutely unsupported by evidence. In this case, you can look at evidence two ways, but there's certainly evidence there for them to justify their verdict. That, you know, you can come up with an alternative, but what they based their decision on was not an unreasonable view of the proof, and that's what we have to look at. We can't go in there and second guess the jury.
The main problem here is that what we're contesting is that the prosecution did not prove this case beyond a reasonable doubt.
That's true, but counsel, at this stage, he's been convicted by a jury, and every reasonable inference is viewed in favor of the state from our standard of review. So I think what my colleagues are asking you is, tell me how some of these inferences are unreasonable.
Well, at trial, at the appellate level, the guilty verdict does replace the presumption of innocence with a presumption of guilty because, of course, presumption of guilty has been established, and now the plaintiff must reestablish the innocence. What he's challenging is that that just simply was not him at the crime scene.
All right, let me ask you this. Let's just say, let's forget the proof at this time of who was driving the black SUV. Would you admit whoever was driving the black SUV that followed Pastor Jenkins from this, did I get the right name? No, Pastor Floyd from this gas station, pulled up beside him and shot apparently 11 times, did so premeditatedly?
Yes.
Okay, so the issue of premeditation is not really the issue. The issue is identification, correct?
Correct.
We've been through that, I think, enough. All right, go ahead, counsel.
Okay. Again, it is impossible to prove when the shots were fired, and there were no fingerprints on the shell casings to definitively link the casings to Jenkins.
But the expert said that the heat or the pressure generated when a shell casing is fired through the barrel of a pistol, in this case, would, in all likelihood, destroy any fingerprints. Is that correct?
Yes, but that just means in all likelihood there's still a small chance. Counsel therefore requests an order overturning Jenkins' conviction. Additionally, counsel would like to point out, post-filing of the brief, Pastor Ricky Floyd is deceased. Pastor Floyd was a friend of Steve Mulroy's when he was alive, and counsel therefore asked for consideration of recusal for the Shelby County District Attorney's Office.
I didn't follow that. Say that again. What was that about?
Ricky Floyd was murdered in a bar fight after we filed our brief. This happened, I think, last month. And it came out that he was actually a friend of Steve Mulroy, the DA, District Attorney of Shelby County. And so we are asking for consideration of recusal.
I don't think we have anything in the record about that, I don't know anything about it. I don't know any of the parties you're talking about other than seeing their name in this brief. I don't think that's before us.
No, and I think if this case gets remanded back, then you can address the court and the DA's office at that time whether or not they think recusal should be appropriate. I don't necessarily know if the fact the DA knows a particular person's going to disqualify them, but that would be something that you would take up at a later date. Right? Okay?
If there are no further questions, thank you, Your Honors.
Thank you. General Lapone?
Yes, good afternoon, Your Honors. May it please the court, Ray Lapone on behalf of the state of Tennessee. This court should affirm the judgment of the trial court. It should absolutely not take this verdict away from the jury. Based on Judge Holloway's recitation of the facts and the questions from you, Judge Campbell, and you, Judge Wilson, I won't go back through all the facts of the case because I think Your Honors have a good grasp of those. What's important here, and based on Your Honor's questions, is did the jury see all this? What did this jury have as evidence before they returned their verdicts? Because that's really what we're talking about here as it relates to the standard. The jury gets to resolve the questions of fact as it relates to identity, premeditation, and even intent to kill, and they absolutely did that. The state respectfully submits that the appellant is attempting to ignore the law as it relates to circumstantial evidence. As Your Honors well know, a jury can convict reasonably on both circumstantial or direct evidence. And here, the state submits the circumstantial evidence is overwhelming as it relates certainly to the main issue of identity. And Your Honor, Judge Holloway mentioned the video. Your Honors have it, you can see it, but the jury looked at it. They heard the testimony from Pastor Floyd, and they watched that video, and they watched the defendant get out of that car in that gas station after waiting on Pastor Floyd and Mr. Thomas to pull in. They saw the defendant get out, who was absolutely identified, as Judge Holloway pointed out, by his wife. And if the appellant wants to make the argument that she backed off that testimony, which the record will show that, but the jury resolved the issue of credibility of the wife attempting to back off her identification of Mr. Jenkins 3 times to the police after they enhanced that tag number and tied that car to him and to her. And when you look at even the employing of a firearm, the second the police found that shell casing on the front windshield outside of the driver's side with the facts of how quickly that shooting happened after Mr. Jenkins pulled out of that gas station, not getting gas, certainly exchanged some words, that video showed the jury that car go all the way back around and sit and wait for them to pull out. And Your Honors have this in an exhibit. The state actually put together a map. It was an interactive map to show how fast after Pastor Floyd pulled out and Mr. Jenkins got behind him, how fast those shots rang out after he followed them, pulled around them, and fired over 10 shots into that vehicle. And the jury saw the truck, the holes in the car, and they heard the evidence that Pastor Floyd was struck. So all the elements of the offense were proven well beyond a reasonable doubt, and this jury absolutely, any rational juror could see this evidence and easily conclude that he was the shooter, that he followed him, and that he attempted to kill him. If your honors have no additional questions of the state, we'd ask you to affirm the verdict of the trial court.
Anything?
I say additional, I don't know if you asked me a question. But any further questions?
No. Thank you, I don't think so.
Thank you, your honors.
Your Honors, Your Honors, there are multiple factors to consider in considering whether there was a proper intent, if there was the requisite mental state. In this case, it was intent. One of those factors is motive. Pastor Floyd admitted at trial that he had never seen Mr. Jenkins before in his life. This contradicts when he claimed that he saw him at the gas station. The fact that Pastor Floyd did not know Reginald Jenkins or did not know who shot him and they did not get a good look, that alone does break apart the requisite culpability necessary for first-degree murder and necessary for intent. Well, it is true that someone did get out of that car at the gas station. Someone did pull across the street. Someone did follow them and shoot at them in a black vehicle. We contend that it was not Reginald Jenkins. We continue, the appellant's position continues holding that that was a different vehicle and a different driver, because there is no hardline corroborating evidence confirming that that was Reginald Jenkins. We continue holding our argument that he did not commit the attempted first-degree murder and he did not have a deadly weapon in his hands to commit a dangerous felony. Accordingly, the undersigned counsel respectfully requests that his conviction be overturned.
Thank you. Okay, we're going to take a short break.
All right.